In our previous class, we had already discussed this. So ways in which an agency can actually be terminated. So we saw, so there are several ways. So what are the ways? Maybe you can just be able to mention them very fast. Be able to mention them. You can be able to list them down there on the chart I see. You can be able to remember them. Ways in which an agency can actually terminate. So ways in which an agency can actually terminate. So what are the ways? Ways under which an agency relationship can actually terminate or come to an end. So I can see bankruptcy, death of the other party, lapse of time. So insanity of the either party. So insanity of the either party. We can have also performance. We can have bankruptcy, we already mentioned, frustration of the contract, cessation of an emergency. Basically, it is agency out of necessity, cessation of cohabitation. So post majore until post majore. So circumstances beyond the parties. So circumstances beyond the parties, or which the parties don't have control over. So post majore. So through frustration. Yeah, so I think you are able to mention them. So then the other question is about from an outline for circumstances under which an agent may be held personally liable to third parties. So we are saying generally, we say that generally for contracts of agency, the person who is supposed to be held liable is normally the principal. But under exceptional circumstances, you'll find that the agent has actually been held responsible. So what are the circumstances under which an agent, so negligence, so I can see negligence, so negligence. So circumstances under which an agent might be liable to third parties. So undisclosed terms. So the circumstances under which an agent might be liable to third parties. So we said, for example, where he executes a deed in his own name, where the agent expressly or impliedly consents to a personal liability, where he acts beyond his authority or actually exceeds his authority as the agent. So where the principal does not actually exist at all, or the principal is not actually in existence or no longer in existence. So where an agent executes a deed in the principal's absence, in circumstances in which his appointment was not actually by agreement or by deed. So where he acts negligently, which it has already been mentioned by Rias there. So where the principal does not actually exist, he agrees to liability. So I think you can be able to mention them. You can be able to mention them. So that's in the same past paper. So there's another question. So I'm getting another question. So so there's another question which I want to get. So I want to get another question on agency. Let me see if I'll be able to get it. So I'm not getting another one for agency for right now. I'm not getting another one for agency, but I think I'll be able to get it later on. I'll be able to get it later on. So maybe we can proceed with the contract of insurance. Contract of insurance for now. Contract of insurance for now. So you can continue with the contracts of insurance. So there's someone asking, what about the type of agent? So we have to look at the type of agent. So the type of agents that we can have. So we have to look at the type of agents before we can proceed with the maybe contract of insurance. So maybe you can just be able to mention them. So you can have a broker. So you can have a broker. You can have a factor. You can have a broker. So it's simply a mercantile agent who has neither possession of the goods nor documents or title to the goods. So they're like middlemen, brokers. So a broker is simply a mercantile agent. So it's simply an agent who has no possession of the goods nor documents or title, but who is engaged to make bargain or contract. Who is actually engaged to make bargain or contract. So that is number one type of agent that we can have. Then number two, a factor. So we can have a factor. It is an agent who is entrusted with possession and sells the goods in his own name. So it's actually a factor. So you can be able to see a broker doesn't have the title to the goods, but you can actually be able to enable transactions or contracts to happen or transfer of goods. A factor, so it's actually an agent who is actually entrusted with possession of the goods and sells the goods in actually his own name. In his own name. Then you have an auctioneer, an agent who is actually licensed by the state to sell goods and other property by public auction. So he may not be entrusted with the possession, but it is an agent for both of the parties, so the buyer and actually the seller. So it's an agent who is actually entrusted or given the authority by the state or actually authorized to be able to carry out what we call auctioning of goods. Auctioning of goods. So he's known as an auctioneer, so he can also be an agent. Then you have a del creder agent, a del creder agent. So a del creder agent. So you can have a del creder agent. So a del creder agent. So is a mercantile agent who in return for an extra commission, known as commission del creder, guarantees solvency of a third party with whom the principal actually contracts. So a del creder agent simply gives the assurance that a third party is actually quite solvent enough. So he has enough money to be able to pay for maybe goods. So he gives the assurance that a third party will actually be able to pay. So maybe you can leave the goods with a third party and of course inform the principal that he'll likely be able to pay. So he gives the guarantee or the assurance of the solvency of a third party. Then he undertakes to indemnify the principal if the third party fails to pay for the goods or pay for the amount due. So it'll be known as a del creder agent. A del creder agent. Then we have a ship captain or a master. So he's an agent with the powers over a ship and its cargo. So a ship captain can also basically be taken as being an agent because he actually safeguards the goods. He actually safeguards the goods. Safeguards the goods. So I can see Riaz is asking for the notes. So I think I'll be able to, I'll just share this note maybe after this one. Let me see that I'll be able to share after the class. After the class. So I'll share the notes after the class for agency. So those are the types of agents that we can actually have. So I want us to start looking at the contract of insurance, but there's a question which has been mentioned, CPA 2016 question 5C. So let me see that question 5C, 2016 question 5C. So May 2016 question 5C. May 2016 question 5C. So I can be able to see the question. I can be able to see it. So question 5C. So it says, describe the 3 conditions necessary for valid ratification of in the law of agency. For valid ratification in the law of agency. So those are basically the requirements for agency to be created by what we call ratification. So it is one of the ways through which we say agency can actually be created. So known as ratification, agency by ratification. What are the conditions necessary for that agency to be created? So I think it's part of the last thing we looked at in the previous class, but let me just share it. So creation of agency, so by ratification, so they're here. So however, for agency by ratification to arise, the following conditions are actually necessary. So there are these ones. So the agent must have purported to act as a principal. For a principal, must purported to act for a principal. The agent must have had a competent principal. The principal must have had capacity to enter into the transaction when the agent did, as well as when he actually ratified it. The transaction entered into by the agent must be capable of ratification. The principal must ratify the transaction within a reasonable time. The principal must have been aware of the material fact affecting the transaction. The principal must ratify the contract in its entirety. So these are the answers to that particular question. These are the answers. So I'll be able to share these notes maybe after the class. So maybe you can start on the contract of insurance. Contract of insurance, it is another contract. It is another contract. So the contract of insurance, there are usually two parties. So you have the insured and the insurance company. So the insured and the insurance company. So in this case, basically the insurance company actually undertakes. It actually undertakes in consideration for a sum known as basically premiums that they'll actually be able to pay or actually compensate the insured party an equivalent amount in case of a happening of a specified event. In case of a happening of a specified event. So it could be a road accident, it could be loss of life, it could be a health issue. So they just basically undertake. So you give them premiums as the insured party, and of course they actually undertake to be able to compensate you as the insured in case of a happening of a specified event. If it is health, that simply means sickness. You actually admitted with those people. If it is a road accident, you go to compensate you maybe in terms of loss of life or maybe the motor vehicle. So that is what we mean by a contract of insurance. And of course, there are usually two parties. So the insurer, or basically the insurance company, and of course the insured party. The insurance company and of course the insured party. So there are different types of insurance. So we can have, for example, what we call an indemnity insurance or non-indemnity insurance. So personal insurance. We can have maybe property insurance. We can have liability insurance. Things like, let's say, for example, maybe NHIF, NSSF. So you can have, for example, insurance for maybe things like burglary or a happening of an event like burglary, or maybe fire, so fire insurance. So those are some of the different kinds of insurance that we can actually have. So then there are key characteristics. So there are key characteristics about an insurance contract. So there are key characteristics about an insurance contract. So there are key characteristics about an insurance contract. So it is usually through an agreement. It happens through an agreement. So for a contract of insurance to exist, there must be an agreement under which the insurer is legally bound to compensate the other party or to pay a sum assured. or to pay a sum assured. So this is the consideration that passes between the party to support the transaction. It is asserted that premium is the consideration which the insurance received from the insured in exchange for their undertaking to pay the sum assured in the occurrence of an event that is actually insured against. So in this case, what you'll be able to, so because you said under each and every kind of contract, you'll have a consideration that will ask to be paid. So under contract of insurance, the insured, the consideration he actually gives, it is normally premium. So you'll be able to pay what we call premiums each and every month. So if it is NHI, we pay monthly. To pay monthly a minimum amount of 500. So that is the premium you actually pay. In case of a happening of an event like sickness or matters to do with health, then NHIF as an insurance, so you can actually be able to cater for that particular amount of bill at the hospital. So there's normally what we call payment of premiums by the insured party, parties. So they'll be able to enter into an agreement, and of course now in this case, under this particular agreement, there'll be considerations that will have to be given, for example, by the insured party. What is actually normally the payment of the premiums. Then uncertainty, these events that are normally insured, they are quite uncertain. You can't actually be able to predict and say they'll happen at a particular time. So the insurance contract is aleatory, contingent, or just speculative, as it deals with uncertain future events. For an event to be insurable, it must be characterized by some uncertainty. So you've insured your house against fire. You don't know when the fire will actually happen. You're just speculating. It can either happen or not happen. So you've basically taken a health insurance policy. So you can't tell that you maybe fall sick or maybe you'll be healthy. So you can't easily tell. You're just speculating with uncertainty. You've insured your motor vehicle against accident or maybe an event. So you're not actually sure when it will actually happen. It can even pass a whole year that it has not actually happened. It can just be healthy for a whole year. So it is insurance basically deals with what we call speculative events. So things that you can't actually be able to predict that they'll actually happen. So maybe they can happen or they cannot actually happen. It is characterized by what we call uncertainty. So when you take the insurance policy, it doesn't mean that, of course, that event you are basically taking it for will actually happen. But you're just basically taking it for maybe uncertainty or events arising maybe beyond your control. You can't actually be able to tell when they are actually happening. And then there's usually what we call an insurable interest. The insurable event must be of adverse nature. So the insured must have an insurable interest in the property, life, or liability, which is the subject of the insurance. Insurable interest is said to be the pecuniary or financial interest which is at stake or in danger if the subject matter is not insured. It is a basic requirement for a contract of insurance. So usually what we call the insurable interest. So in each and every insurance policy that you basically take, you'll have what we call an insurable interest. You'll have an interest, financial interest in it. So if it is a motor vehicle, so you are basically the owner of the motor vehicle. In this case, in case of a happening of an event, so maybe you might lose the motor vehicle. So it simply means that you'll be compensated. You'll be compensated by being given the motor vehicle because you're actually the owner. You have an insurable interest. There's something that you are likely to lose if that motor vehicle is not actually there, because you're the one basically who has actually spent the money to be able to acquire the motor vehicle, and the title or actually ownership is actually in your name. So you have an insurable interest in that case. So they'll be able to ascertain part before you become the insured party that whether you actually have what we call an insurable interest in the subject matter. Insurable interest in the subject matter. Control. So the insurable event must be beyond the control of the party assuring risk as it was actually held in that particular case law. Sentinel Securities PLL. So it must be something that it is beyond your control. It is beyond your control, so you will not be able to control it. Accidental or negligent loss. Insurance can only be effected where loss is accidental in nature or is a consequence of negligent act or omission. So loss occasioned by intentional act does not qualify for indemnity or for payment of the sum assured. So you basically led to the event actually happening by yourself. So that simply means it was actually intentional. So intentional events basically you won't actually be compensated by the insurance company. So they'll be able to look at the circumstances under which the event has actually happened. So was it accidental? So accident events, of course, they're likely be able to compensate you for that loss. Risk. So risk has been defined as the chance of a loss. So the probability of loss or the probability of any outcome different from what is actually expected. It is a condition in which there is possibility of an adverse deviation from a desired outcome that is expected or hoped for. For individual purposes, risk is measured by the probability of loss as the individual hopes that it will not actually occur. So this particular aspect of risk is normally very important in insurance policies. So they just look at the probabilities. What are the chances that you'll actually fall ill? So in this case, when they do the computations, for example, for premiums, they're actually able to engage experts, so actuarial scientists, to be able to look at the probability, the risk. That if, for example, if all of us have taken a health insurance policy by from Jubilee, so what are the chances that out of all of us, someone will be able to fall sick and of course be admitted at a hospital? They're basically looking at probability, the chances. So these events, they're not actually sure whether they happen or they cannot actually happen. So it is just basically like a game of chance, a game of probability, a game of chances. You just look at the chances as to whether a particular event will actually happen. So with that, of course, now these expert actuarial scientists can actually be able to calculate or do the computation in terms of, for example, how much premium can actually be paid. So insurance just basically play with chances. They play with chances. So what will be, for example, in this case, if all of us have actually been able to contribute, let's say, for example, maybe 60,000 total premium for a whole year. But of course, maybe like half of us have actually fallen sick. And of course, we have been admitted at the hospital. It simply means that maybe we'll have to, the insurance company will have to put a bill of, let's say, for example, maybe 200,000. You can imagine if we contributed premiums of 60,000 total in a year, then of course the insurance company is going to put a bill of 200,000 for all of us. That is simply means that the insurance company will actually be in a negative of 140,000. So you can be able to see they're just looking at probability. What are the chances? And then they do proper computations of how much can actually be paid as premium. So of course, in this case, if they spend less, for example, on medical insurance, simply means that they'll be able to retain most of the amount as profit. So I think later on in financial reporting, you'll likely be taught how to be able to compute financial statements for insurance companies. Later on, also basically you'll be taught maybe things to do with maybe probabilities, quantitative analysis. I think that is what most of you are actually covering. So just look at the chances. Of course, they calculate as to how much can be paid as premium. Insurance company can even go at a loss. So you have to basically do proper computations. So that's why people go to study actuarial science. So that is basically their work. So that is what they do there. They do valuations for the insurance companies. They do numbers for the insurance companies. So the insurance company basically will actually end up having to make something or actually make up a profit. And of course, generally, if you look at the insurance sector, so most of the time you find that they don't actually make a lot of profit, like actually compared to, let's say, for example, maybe the banking industry. So banks will hear they have made profits of, let's say, for example, maybe 15 billion and 30 billion for equities, KCBs, and 7 billion. The insurance company that is like probably maybe the biggest, the largest in the country, like Jubilee, they have made a profit of 1.5 billion. So that's why you're saying they just look at the chances. So they can go off. Sometimes they can basically be okay. Sometimes it just depends with probably what are the events, what are the premiums, what are the amounts they have to pay back to the insurance plans. So all those have to be considered. So they have to be considered. So they have to be considered. So I can see Beatrice is asking, I give an example of control. So they're saying insurance event must be beyond the control of the party assuring the risk. So that is the case. That is the case. So these events that you actually go for insurance, they are beyond your control. They are beyond your control. An accident you can never control. You never know. You will never know when it will actually happen. It is beyond your control. Matters to do with health. You can't tell whether you'll be sick tomorrow. Just speculating. You're just speculating. The events beyond your control. The events beyond your control. Life insurance policy. So they do computations. For example, if you lose life at a particular point, they pay back you a particular amount. Loss of life beyond your control. So you can't control these events. Those events are basically beyond your control. Health, you can't tell. If tomorrow you can't tell. You can't control it. Accident, you can't control it. A disaster like burglary, basically done insurance for burglary. You don't know whether tomorrow people will come to steal your property. There's events beyond you can't control them. That is what we mean by they should be beyond your control. These events are normally beyond your control. Beyond your control. That is basically what they mean by control. You can't control them as a person. You just go to take an insurance policy for health. You're just speculating. It can even take a whole year. You've not actually fallen sick. Just okay. But you had actually taken a policy for health, or maybe your employer was actually paying for it. So those premiums, basically, the insurance company just consume. So the next year, that policy has to be renewed like that. So these events that you go for insurance are usually basically beyond. You can't tell. You can't say tomorrow. You can't control and say tomorrow I won't be fit. So you never know. You never know when it will actually happen. So you're just speculative event. Well, there's one of the points that I'm exactly talking about. They're uncertain. They are very uncertain, and you can't control them. They are very uncertain. You're just speculating. You can't even control them. You can't say tomorrow I won't have an accident. So accident is an accident. You can't tell. That is what they mean by control. So formation. So how did this particular contract actually formed? So a contract of insurance comes into existence when an offer by the proposer is accepted by the insurer. So the proposer makes the offer by completing and submitting to the insurer the proposal form. So they'll be able to come to you with a form. So they'll come to you with a form, and then of course now in this case you'll be able to propose this. But in this case, give the offer. So the proposer makes the offer. So you are the one who actually makes the offer. So you can be able to say they give you the form, you make the offer to the insurance company, so they'll be able to assess. You tell them, so these are my details, my particulars. So those are basically the things you'll be able to provide. Particulars of the proposer or the insured party. Particulars of the subject matter. So subject matter in this case we mean, for example, if it is maybe motor vehicle insurance, health insurance, life insurance, the fire insurance. So that is the subject matter. Fire insurance, or maybe your house. So like that. So circumstances are affecting the risk, the history of attachment of the risk. So they'll actually ask you about your history, especially if it is a matter to do with health, or maybe life insurance policy. So we're going to see later on that there is one of the principles under insurance. It is actually known as the principle of utmost good faith, or the principle of what we call in Latin, you must actually always act with utmost good faith. And in this case, the questions they'll be able to ask, for example, in your family tree, maybe your grandfather, your father, is there anyone basically who has actually been affected by a terminal disease? Those are the things that they actually able to look at, and of course, do the computations of the probabilities. What are the chances that this particular client of ours is likely to fall? So maybe now they quote the premium, so they could maybe basically be so high. it could actually basically be so high. So in this case, you'll find that for insurance companies, if a disease is actually very contagious, so they're likely not actually to be able to allow to be able to cover for such kind of a disease, because they know they likely go at a loss. So maybe you might be wondering, for example, during the pandemic, so COVID, so many insurance companies were not actually basically allowing for their clients to be able to pay using insurance with their insurance cards or maybe insurance policy. Because in this case, there's actually a pandemic. So high chances the numbers of those who are going to fall sick, they are so high. And the kind of bills that are expected to be paid will be basically be so high. So the insurance company will simply go into the negative. So in this case, if it is maybe they have like 1 million clients, out of their 1 million clients, so there's a contagious disease. So there is basically a pandemic like COVID. Out of their 1 million clients, 900,000 are actually affected by COVID. Simply means they have to put for the bill of these 900,000. So that's why we find that certain insurance companies will be able to cover for certain matters, matters to do with health. Maybe they say you can be able to use this one for chemotherapy, you can be able to use this one to do this and this. Say, for example, NHIF cannot actually be able to maybe cover for certain areas or certain matters. So those are basically the reasons as to why. So they see if we are actually basically going to cover for this, then maybe we have to cap up or basically ensure that the premiums being paid are actually quite very high. So, and maybe most of the people might not actually be able to afford. So in this case, they'll be able to look at the circumstances of situation actually in place before maybe they craft their insurance policies, basically to sell them to their clients. So during that particular time whereby you're actually negotiating or going to enter into this particular contract of insurance, so there's a principle of what we call the principle of utmost good faith. It is expected that, of course, the insurance company doesn't actually know your history. Basically, you can even lie to them that no one in my family has actually been affected by a terminal disease. So they might not actually be able to ascertain that one at that particular point. And of course, they won't ask for any further evidence for you to be able to provide to just basically ensure that there's no one who has been affected by a terminal disease. But of course, as to why they ask you to act with what we call utmost good faith, later on if they discover, so there can be consequences. They can be able to withdraw that particular contract. And of course, maybe fail to even cover for a certain or a particular ailment or maybe disease. It is expected during the negotiation process, especially from the side of the insured party, that you'll actually be very truthful and give information that is basically factual or very true. You act with what we call utmost good faith. So that's why they ask those kind of questions. They'll never ask you come to ascertain or maybe come to your home and start looking for your grandfather or maybe your father. So there's the expectation that you as a client of the insured party will be able to act with what we call utmost good faith. Utmost good faith. So that is one of the principles, and that's why they are saying there they'll be able to ask the history attachment of the risk. History attachment of the risk. So they'll be able to find out as history about that particular subject matter that is actually going to be insured. So the proposer signs a declaration at the bottom of the form to the effect that the answers given constitute the basis of the contract between him and the insurer. The declaration is referred to as basis of contract clause. Basis of contract clause. Acceptance of the proposal form. So now in this case, you are the one who basically now gives the offer to the insurance company. They will offer to basically be their client or maybe customer. So they'll be able to look at the form. So they're the ones who can either reject it or maybe accept you to be the client. So acceptance of the proposal form, the insurer is not bound to accept the proposer's form. It is not a must, so they'll have to accept. But of course, they are always actually running around looking for clients, so high chances they just accept. So long as you have the capacity, the capability to pay the premiums. So they know if basically they likely refuse to you to be their clients, so they just accept. If they know you are very financially very stable, so you are working, so they just basically accept you to take up the policy. So after all, they are looking for a number of clients to be so many of them so that they can be able to reduce the risk. So if it is accepted, It signifies the contractual relationship between the two. The insurer may signify acceptance of the proposal form by a formal communication, maybe through an email, or maybe by conduct, by issue of the policy. So you get a policy document. They send you a policy document, maybe in your email, maybe they can give you by hand, so like that. So acceptance and retention of premium raises a presumption of acceptance of the proposal form. So they're usually very aggressive, very aggressive. So they'll tell you, Mr. Njiru, that this is the bank account. You can actually be them to pay the first premiums right now. So once in this case, you just wire the amount, and of course, they actually accept. So by that particular fact that they have actually accepted the premium, simply means that, of course, they have actually accepted your offer. So they have accepted your offer. So they'll be able to retain, because they'll be very aggressive. They ensure that you pay the first premium. They'll even give you the bank details. So they'll ask you to even fill out bank transfers, basically bank checkups, so that maybe at the end of the month or when the salary comes, they just do a checkup, the amount goes to their account. So once they do that and you pay the first premiums, so by the fact that they have accepted the premium, by their conduct, they have simply implied that, of course, now they have actually accepted your offer to become their client. So classification of insurances. So insurance contract may be classified on the basis of the event insured, the interest insured. So the event insured, the category of insurance derives its name from the event, e.g. fire, burglary, marine, so fidelity, or a motor vehicle. The interest insured, so this one can be categorized as personal insurance like life insurance, property insurance, liability insurance like NSF, NHI, third-party motor vehicle insurance. The nature of the contract, by nature of the contract, an indemnity contract, non-indemnity. Indemnity is a contract whereby the insured takes out a policy on the understanding that when the loss occurs, he will be compensated for the loss. So this is property insurance, e.g. fire, burglary, or marine. Non-indemnity is a contract whereby a party known as the insured takes out a policy to secure the payment of a sum of a certain money when the risk attaches, e.g. life insurance. I hope you must have come across this one, or maybe you have taken this one, life insurance policy. So what they do in this case, they do calculations for you. So because of maybe loss of life, so this is the amount that basically will be left to your next of kin, so maybe your children, so like that. So in this case, they are saying whereby a party known as the insured takes out a policy to secure then their payment of a sum of a certain amount when the risk actually happens, So life, so that is life. So there's actually loss of life of the insured party. Then of course the amount can actually be paid to the next of kin. So the next of kin to basically be left secure. They'll be left secure. So maybe they can put a maturity period of maybe 15 years, maybe they can put maybe like 20 years, it just depends. Because in case of happening of an event before that 15 years, so there's an amount they actually give an assurance, they'll actually be able to pay to the family of the insured party. So whether private or social, so private insurance is optional while voluntary. Social or compulsory insurance is statutory requirement, e.g. third-party motor insurance. So social is simply basically the thing private insurance is optional while voluntary. So private is actually optional while voluntary. Social or compulsory insurance is a statutory requirement. And then basis of the program, so you can have insurance or reinsurance. So reinsurance. So insurance is just directly as what you've been able to see, and relationship between the insured party and the insurer. And then you can have reinsurance. So these are contracts in which the insurer insures himself with another insurance company. So what happens in this case now, for example, if it is a small insurance company, they'll be able to maybe insure their premiums with another bigger insurer, like a mother insurance company. They do what we call the reinsurance. So they get clients as an insurance company, but of course now they also insure themselves they do reinsurance. So they insure themselves against other risks with other insurance companies. So that is the reinsurance. So what are the principles of insurance? So that is what I've just been talking about. Insurable interest, you've been able to look at it. So this is the financial or monetary interest at stake or in danger if the subject matter is actually not actually insured. It is the interest a person has in the subject matter which he stands to lose in the event of its loss or destruction. So if you don't insure your house against fire, if fire happens, then you're likely to lose it. So that is the interest you have in that particular property or subject matter. So loss of the house. So these are financial interests that you have in the subject matter. So to ascertain whether a person has an insurable interest in the subject matter, the court employs the following rules. There must be a direct relationship between the insured and the subject matter. So maybe you're actually the owner, you have the title deed exactly basically in your name. So the insured bears any loss or liability arising out of it. The insured must have a legal equitable interest or right in the subject matter. The insured interest right must be capable of financial pecuniary estimation or qualification. So it can basically be put in financial terms. It can basically be said, for example, this house, it has a value of maybe 2 million, maybe 3 million, so like that. So there should be a value, financial value actually attached to that the subject matter connected to the insured party. Principle of utmost good faith. So if the duty to disclose exists throughout the negotiation period, it is generally comes to an end when the proposal form is actually accepted. So that's what I was talking about. So the principle of verify the act with utmost good faith always during the negotiation process. So effect of non-disclosure. So the non-disclosure of material facts by either party renders the contract voidable at the option of the innocent party. So in London Assurance Company versus Mansell of 1879, when responding to a question in the proposal form, the proposer stated that no other insurer had declined to take his risk. In fact, 2 companies had previously declined to insure him. So that is what he actually said. He was actually lying. He was not actually telling them the truth. Mary, not on this. Mary. Maybe we are not on mute. So we are saying that responding to a question in the proposal form, the proposer stated that no other insurer had declined to take his risk. But of course, in fact, 2 companies had previously declined to insure him. Subsequently, the insurer sought to avoid the contract on the ground of non-disclosure of material facts. So that the contract was voidable at the option of the insurer for the concealment of material facts. A similar holding was actually held in the case of Horn versus Poland of 1922. So if you don't basically reveal material facts or truthfulness, then if it is discovered, then you can be able to see the contract can actually be avoided, by the innocent party, So you actually lied. There is no one basically who has been affected by a terminal disease in your family. But of course, now the insurance company discovers, or they can be able to avoid the contract. By simply avoiding, they simply mean they basically terminate, or they just let it come to an end, so they can be able to avoid the contract. So although the contract of insurance is one of the utmost good faith, certain matters need not to be disclosed. They are quite obvious. So provisions or propositions of the law. So things that are basically already provided for in the law, you don't have to disclose. So it's not a must you ask that you disclose on the form. They are basically obvious things that are provided by, for example, mother laws. What do you mean by mother laws in this case? For example, the Constitution, an Act of Parliament. So there's already a law in place that is basically revealing those particular information. So you don't have basically to be compelled to have to reveal them. So a known fact, as was in the case of Joel versus Law and Crown Insurance Company, facts known by the other party. So quite obvious facts. So known facts are things that basically you can't force someone to know. So he doesn't know. So he doesn't know. So in this case, for example, now you start asking the history beyond the grandfather. So those are things that probably this person might not actually be knowing. So you ask Jen that your great grandfather has been affected by terminal disease. How will Jen actually be able to tell? Those are known facts. You can't basically force someone to be able to reveal them. So maybe you can just be able to go up to the extent of the grandfather. So maybe you saw actually his or you saw her grandfather. But now the great grandfather, so you've just been told stories about him, but he doesn't actually know about him. So if they are known facts, then there's no need to force someone to be able to reveal. So facts that are quite obvious or already known by the other party, you don't have to reveal. For matters of public notoriety, as was in the case of death versus Hamet. Death versus Hamet. So those things that basically you are called upon not to be able to reveal, not to be able to reveal. Then indemnity. So indemnity simply means compensation. So under insurance contract, there's the aspect of compensation. So the insurance company will be able to indemnify. To indemnify simply means to compensate in case of a loss. So the principle means when a loss occurs, it is the duty of the insurer to restore the insured to the position he was before the loss. So the insurer must, so far as money can do, put the insured in the same position he was actually before. So loss of a car through an accident, a new car. So the same position, a new car. Loss of a house through maybe fire, a new house. Same position to likely basically be compensated or actually be indemnified. So indemnity means that there should be no more or no less than restitution integrum. Restitution integrum basically simply means return to the original position. Return to the original position. So no less than the original position. Restitution integrum. Restitution integrum. So indemnity is a basic principle in property insurance. It has its justification in equity, in that if absent, the insured is likely to benefit from the contract. Is likely to benefit from the contract. So the principle of indemnity is given effect by the subordinate principle, e.g., subrogation, salvage, reinstatement, contribution, and apportionment. It's supposed to not be appointment, but apportionment. So those basically are likely connected to what you are calling indemnity. So what is subrogation? So there's also the principle of subrogation. It means that after the insurer has indemnified the insured, the insurer has indemnified the insured. So they have already compensated. What happens? That the insurer will actually step into the shoes of the insured in relation to the subject matter. In relation to the subject matter. So for example, now in case if it is actually basically a motor vehicle, if it is badly damaged, so the insurance company will take that motor vehicle. And of course, now in this case, they'll give you a new motor vehicle. So they'll step into the shoes of the insured with regard to the subject matter. If it is a house, if they give you a new house, probably they will take that one that was destroyed by fire and maybe renovate it, maybe do something with it. So it will be theirs to step into it, to be subrogated, to step into the shoes. So they'll basically be able to bear all the, or enjoy all the equitable rights and bear all the liabilities with regard to the subject matter. Bear all the liabilities with regard to the subject matter. So it means that after indemnity, the insurer becomes entitled to all legal and equitable rights in respect to the subject matter previously exercisable by the insured. Subrogation facilitates indemnity by ensuring that the insured does not benefit from actually the contract. So salvage, so this is the recovery by the insuree of the remains of the subject matter after indemnity. It is part of subrogation and facilitate indemnity. So you can be able to see they are almost connected. But now subrogation, in this particular aspect, you're talking about equitable right. Equitable right. So subrogation is basically more focused on equitable, the right to enjoy over that property. The right to enjoy over that property. For example, now in this case, it will now become yours. You'll be able, for example, if it's a motor vehicle, you can be able to repair it and drive it. If it's a house, you can be able to repair it as an insurance company and maybe sell it off. So you enjoy the equitable right. But now what we mean by salvage, the point is remain. Salvage is the remain. Subrogation, the right. You enjoy the right. So you sleep in the house and actually just enjoy it. The judge basically sits in the sitting room. So you're actually enjoying the rights over that particular property that was actually insured. But of course, now in this case, you've already compensated the insured party. So now you take over that one and enjoy it. So subrogation, basically the right, attached to the right. Salvage, the remain. The remain talks more about the remains, although they are just almost connected or same like that. You can be able to see they are saying here that it is part of subrogation. It is part of the right that you actually enjoy under subrogation. Subrogation now basically focuses on all the rights you enjoy over the property. You can just walk there anytime you want, because it has become yours as an insurance company. You can close the place, so you're enjoying the right. You have the keys to the house, so it is now yours. Reinstatement. So this is the repair or replacement of the subject matter in circumstances in which it may be reinstated. So sometimes they do repairs, they can do repairs, so they can just renovate that house and maybe bring it back to the original position, and now, of course, give the insured person. They just reinstate. They don't give you a new, completely new house. They do a reinstatement. The motor vehicle, they just repair the windscreen. They don't actually give you a fully new motor vehicle. They just repair the windscreen, and of course, they reinstate you back. So the principle of reinstatement, replacement of the subject matter in circumstances in which it can actually be reinstated. So double insurance. So double insurance basically simply means you've taken two insurance policies for the same subject matter. It's a situation whereby a party takes out more than one policy on the same subject matter. For motor vehicle, you've taken it insurance policies for two companies. So the house, you'll be actually insured it against fire in two insurance companies. Double insurance. It is double, it is not one. So it's a situation whereby a party takes out more than one policy on the same subject matter and risk with different insurers, but where the total sum insured exceeds the value of the subject matter. Then if you've taken what we call double insurance, then the aspect of what we call contribution and apportionment will actually come in. So in case of a disaster, that fire, then these insurance companies have to do contribution and apportionment of the risk for the compensation, for the indemnification to happen, for the compensation to happen. With a loss of maybe 6 million of the house, they'll do what we call apportionment among themselves as insurance companies, and of course now do the contribution to be able to compensate the insured party. So if an insured has taken out more than one policy on the same subject matter, that is double insurance, and there is with different insurers, and a loss occurs. Now you have to get the point. The twin principle of contribution and apportionment actually applies. How does it apply? If the insured claims from all the companies at the same time, they apportion the loss between themselves on the basis of the sums insured. Each insurer bears part of the loss. This is the principle of apportionment. They actually apportion the loss amongst themselves as the insurance company. So basically, this Mercedes-Benz that is actually owned by Beatrice. So the Mercedes-Benz is basically worth 6 million. So it simply means that if the insured sum was actually basically maybe 4 million for this Jubilee insurance and maybe 2 million for direct line, so we'll just be able to do what we call apportionment of the sum assured. And of course, reinstate back Beatrice to the original position, give her a new Mercedes-Benz. And of course, now they'll have to be able to apportion the loss amongst themselves as insurance company. So if one of the insurers makes good the total liability to the insured, such insurer is entitled to recover the excess payment from the other insurers. So this is the principle of contribution. This principle is to the effect that an insurer who has paid more than his lawful share of the loss is entitled to receive the excess from the other insurer. So you have to basically be compensated or basically get the contribution from the other insurance company. The principle of contribution is equitable. An insurer is only entitled to contribution if the following conditions actually exist. So there must have been more than one policy on the same subject matter. The policies must have been taken out by or on behalf of the same person. The policies must have been issued by different insurers. The policies must have all been in force when the loss actually occurred. All policies must have been legally binding agreement. None of the policies must have exempted itself from contribution. The twin principle of contribution and apportionment facilitates indemnity. It facilitates compensation. Exactly what we call the principle of abandonment. It is the surrender by the insured of the remains of the subject matter for full indemnity. So you abandon it. You actually abandon. It entails the giving up the residue to the insurer for indemnity. This principle has its widest application in marine insurance, but generally also applies in case of partial loss or constructive total loss. So the insured must notify the insurer of his intention to abandon the subject matter. You agree with the insurance that you don't want that Mercedes Benz, you want a new one. So if they accept, then they'll be able to indemnify you or give you another one. So you would have basically abandoned the principle of abandonment. So proximate cost. So what it was exactly the cost. An insurer is only liable where loss is approximately caused by an insured risk, and not liable where the risk is expected. So the principle of proximate cause protects the insurer from undue liability. So maybe in this case, you just put your house on fire by yourself. So you can be able to see, and be able to look at the circumstances. What was the proximate cause? What was the cause of the fire? You just basically rammed into another motor vehicle by yourself. So you have to do what we call an assessment and have to look at it. Did you do it by yourself? So they look at the proximate cause. So under this principle, the proximate and not the remote cause is to be looked into. So the proximate cause of an event is the cause to which the event is attributable. It is the cause which is more dominant, direct, operative, and efficient in giving rise to the event. So courts have not developed any technical test of ascertaining what the proximate cause of an event is. They rely on commonplace tests of the reasonable man and among competing causes. One must be more dominant than the rest. The proximate cause need not to be the last of the chain, but must be the most operative in occasioning for a loss to occur. And then how does this particular contract actually come to an end? How is it normally terminated? So by payment of the loss or indemnity, when the conversion has happened, it can happen through a mutual, through an agreement. So then breach of a condition or a warranty. So breach of part of the terms. So then a party can just be able to avoid the contract. Lapse of time. Once the time, it is basically a health insurance policy. So after a year, it expires. You have to basically renew it or maybe pay another premium. With a motor vehicle insurance policy, after a year, it has expired. So you have to lapse of time that basically lead to termination of the contract. By operation of law, so these are circumstances which render the maintenance of the policy impossible. We are simply basically events beyond the parties. We can't be able to control them. For example, winding up or liquidation of the insurer. So you are being insured by Jubilee Insurance. So Jubilee Insurance is basically liquidated or wound up. Liquidation or winding up is simply ending the life of a company. So can you be insured in a company that is not in existence? So it simply means that your policy would have basically come to an end. Because in this case, Jubilee is basically being liquidated. So for example, recently there was actually an insurance company who was actually basically put under receivership. It was a big player with resolution of each one. So it was one big resolution. It was basically put under receivership. So it simply means that if during that particular time you are actually basically an insured party, you won't actually basically get any kind of compensation. It simply means that the contract has been terminated without come to an end. Sale of the subject matter. You just sold that Mercedes Benz of your pitches. So it simply means your contract with the insurance company does come to an end. So it simply means that you are not the owner. That subject matter does not actually belong to you. You don't have an insurable interest anymore in the Mercedes Benz. It has been acquired in this case by Jen. So Jen now becomes the one who has an insurable interest in the Mercedes Benz. So Jen can proceed and actually now take an insurance policy for the Mercedes Benz. So sale of the subject matter. Sale of the subject matter simply means that the contract between the parties, the insured and the insurer, will actually come to an end. So that's how basically these contracts can actually be terminated, and that is the end of the contract of insurance, So I would wish to end there for today. So let's see if we can be able to look at some questions before our next class, our next topic in our next class. So there's a video which I'll likely be able to share together with the note. So alternative dispute resolution mechanisms. So you can go through the video. It's a very small topic. I don't actually intend to teach it in class. I can see Mary is asking on payment of indemnity. So it just depends. With which kind of insurance policy you've actually been able to take up. Because you can be able to see, I think, I don't know if they have been able to explain there. For example, if it is a life insurance policy, once it has matured and they have compensated you, they have basically indemnified you. So you have taken a life insurance policy for, let's say, for example, maybe 15 years. So there's a sum of money been insured to pay after the end of 15 years. Once you've been able to pay, so there's no basically any relationship you have now with the insurance company. It has come to an end. So payment of the indemnity or sum assured in the event of a total loss. So in the case of a partial loss, reinstatement does not terminate the policy. In fact, they have explained here. Reinstatement does not terminate the policy. So it is only in events of total loss. For example, if it is a house, you had insured your house against fire. So it has been destroyed by fire. So they have indemnified you. They have given you a brand new house. So they have basically reinstated you back to the original position. So in such a case, the contract comes to an end. But of course, in others, it doesn't come to an end, whereby, for example, there's the need for some kind of reinstatement, or there's exactly what we call it partial loss. So, for example, in this case, it matters to do with the health insurance. It simply means that you'll enjoy this particular policy for a whole year. So for health insurance, now what can be able to apply is lapse of time. So it won't, payment of the indemnity does not actually apply in all of them. It just depends if it is which insurance policy or which kind of insurance. So for health, for example, it is lapse of time. So that is the end of today's class. So let's meet in the next class. So there's a video I'll share for alternative dispute resolution mechanisms. I'll also share the note. It's a very small topic. Actually, I don't intend to teach it in class, so you can go through that video. And of course, the note I'll be able to share, because I've been able to have shot a video for it already. Lesson 1. So there's lesson 2, which is actually remaining. I'll be able to shoot again. So let's hope maybe all goes well, or God willing, maybe tomorrow I'll be able to shoot lesson 2. Then I can be able to share. So I think with that, we'll move a bit faster, because as I told you, this particular unit is actually a bit wide. So with that, I think we'll be able to move a bit faster, because it is maybe we finish quite early. But maybe by start of next month, the syllabus, then we can revise a bit here, 1 or 2 areas, and see what is likely to be tested. So they frequently will do the revision. So the easier it will be for you to be able to approach the exam. So when I send the video, make sure you go through it, because I won't teach. I don't think I teach that topic in class again. I share the video, and I also share the notes. Then I think maybe we can go to questions in the past papers. Then we'll be done with that topic. So with that, we have come to the end of today's session. So I wish you all a safe night. Let's meet next time.